The conference room on the 14th floor has floor-to-ceiling windows that look out over the city. On a clear morning, you can see for miles. I know that room better than almost anyone because I was the one who chose it. I picked the table. I approved the chairs. I signed off on the contractor who installed those windows. I did all of that 11 years ago when we moved Volantis into that building, and I was trying to make it feel like a real company for the first time. I tell you that because I want you to understand exactly where I was standing on a Tuesday morning in October when a man named Derek Richardson slid a piece of paper across that table and told me I was done. My name is Margaret Sutton. Most people call me Mara. I am 43 years old. For 15 years, I was the Chief Operating Officer of Volantis Technologies. I was also, though Derek did not know this, the majority shareholder of the company he believed he now ran. He did not lead with that paper right away. Derek never did anything directly if he could do it with a certain kind of polished calm first. He was good-looking in a boardroom way, the kind of man who wore his suits like armor. He had been with Volantis for 6 months at that point, brought in as CEO through a search process that I had participated in. I had even voted in favor of his appointment. I want you to know that. I did not dislike Derek. I thought he was capable enough if managed well. What I did not know yet was how little he understood about the company he had just taken over. He asked me to sit. I sat. He thanked me for coming, as if I had a choice. He said the word strategic 3 times in the first minute, which is always a sign that someone is about to say something they have rehearsed. And then he told me. Volantis was undergoing a structural evolution, he said. The operations model was being modernized. The company had contracted with an outside firm. He named them, a mid-sized outsourcing company I had heard of but never respected, to take over all core operational functions. 17 people in my department were being let go, effective over the next 2 weeks, with packages, including me. My role was being eliminated. The letter in front of me provided 30 days of severance. He thanked me for my service. He used the word legacy twice, once to describe my contributions and once to describe the model I had built, in the way people use that word when they mean something is old and should be replaced. I looked at the letter. I read it once all the way through. It was 1 page. There was a signature line at the bottom with my name printed under it. I set it back down. I did not cry. I want to be clear about that. I am not someone who cries in boardrooms, and I have never been. What I felt in that moment was something much quieter than tears. It was closer to a door closing, and on the other side of that door, very far away, something clicking into place. I asked him one question. Did legal review the full cap table before this meeting? He said yes. He said it the way people say yes, when they mean they assume so. When they mean someone's must have. When they mean the question is surprising enough that a confident answer feels like the only appropriate response. He said it without flinching. He said it looking directly at me. I nodded. I picked up my bag. I stood. I thanked him because I was raised to be polite even when I am at my most dangerous. And I walked out of that conference room and down the hall toward my office, which I technically still have access to for another 30 days. I stopped at my assistant's desk. Her name is Priya. She had worked with me for 7 years, and she could read a room better than almost anyone I had ever known. She looked at my face, and I watched her understand immediately that something had happened. I kept my voice low. I told her I needed her to do one thing for me before end of day. I needed her to send a specific set of corporate documents. I named them, to the personal email address of my attorney. Not to anyone at Volantis, to my attorney directly. She wrote it down without asking why. I walked to the elevator. I took it to the parking level. I got in my car. I did not call anyone. I did not turn on the radio. I just sat there for a few minutes with that 1-page letter on the passenger seat, looking at my own name printed at the bottom of it, and I thought about what Derek Richardson had just done. He had fired the majority shareholder of the company he thought he ran. He had walked into a room with a 1-page letter and 30 days of severance, and he had handed it to the person who owned 51% of everything in that building. The walls, the windows, the table, the chairs, the company underneath it all. And he had done it with a straight face and a rehearsed speech, and the absolute confidence of a man who had not read the documents. I was not angry, not yet, and not in the way you might expect. I was almost relieved, because I had spent 15 years building something, and the people who thought they could erase me in 9 minutes had just made the only mistake that was going to cost them everything. Let me tell you about Volantis, because to understand what happened next, You need to understand what that company actually was, and what my role in it actually meant. I started Volantis 15 years ago with 2 people. The first was my college roommate, Diane Kaur. Diane was brilliant with product. She thought in systems, in user flows, in the elegant logic of how a piece of software should behave. She was the one people wanted to talk to at conferences. She was the public-facing one, the visionary, the name that ended up in industry profiles. I loved her for all of that. It was never a competition between us. We always understood exactly what each of us was for. The second co-founder was a man named Stuart Fenn, who I had known since my second year of work after university. Stuart had a talent for early-stage financing, for making investors feel calm, for turning a pitch into a conversation. He raised our first 2 rounds. He was good at it, and then there was me. I ran everything else. Contracts, compliance, vendor relationships, client governance, the staffing architecture, the internal data infrastructure, the operational backbone that made it possible for Diane to build beautiful things and for Stuart to sell them. When we were 12 people in a rented office, sharing one printer, I was the one making sure we had insurance, that our client agreements were airtight, that our vendor contracts had the right termination clauses. When we grew to 80 people, I built the department structure. When we hit 340 employees, I was still the one who knew where every lever was. I was never the public face of Volantis. I never wanted to be. My name was rarely in the press. I did not do the keynotes or the panels. I was the infrastructure. Invisible, essential, and, as it turned out, very difficult to actually remove. 4 years ago, things shifted. Diane was diagnosed with a serious illness. She stepped back gradually and then fully, selling a significant portion of her equity stake over about 18 months. Stuart had already been transitioning toward a non-executive advisory role, and he did the same, sold a portion of his stake. They sold to 2 outside investors who had been circling Volantis for a while. The first was William Webb, a private equity operator who took a 27% stake and immediately positioned himself as a strategic voice on the board. The second was Helen Cho, a quieter investor, former CFO of a mid-sized tech firm, who acquired a 15% position and said very little at meetings but listened to everything. Together, William and Helen held 42% of the company. I held 51%. A remaining 7% sat in an employee equity pool. That structure was not hidden. It was registered. It was in the original shareholder agreement, in the articles of incorporation, in every foundational corporate document Volantis had ever filed. My majority stake was a fact, on paper in a filing cabinet and available to anyone who asked for the full cap table. But here is what happened. When William and Helen decided to bring in an external CEO, which they had the board-level authority to begin, though not to fully complete without my involvement, they ran the search themselves. They interviewed candidates. They presented a short list. I was involved in that process. I reviewed the finalists. I voted in the board session that approved Derek's appointment. What nobody did, not William, not Helen, not Derek's own legal team, was hand Derek the founding documents. His onboarding review was handled by a small 2-partner law firm that focused on employment agreements and executive compensation. They reviewed his contract. They reviewed his equity grant. They reviewed his authority structure as it was framed in the executive appointment letter. They did not pull the original shareholder agreement. They did not review the governance charter. They did not look at the full cap table with the founding equity structure intact. And because I was the operations woman, the quiet one, the one who had been passed over when they decided a new external CEO was needed, the one who sat in the back of rooms and made sure things worked, it apparently never occurred to anyone to ask whether I might be more than an employee. I watched all of this happen over 6 months. I attended the meetings. I shook Derek's hand. I briefed him on client accounts. I answered his questions about vendor contracts and compliance calendars. I did my job exactly as I always had, and I said nothing. I had learned a long time ago that the people who underestimate you are the most useful people in the room. You do not correct them. You do not announce yourself. You wait until the moment when the truth of what you are becomes impossible for them to avoid. That moment had just arrived. The morning after Derek handed me that letter, I drove to Rachel Osie's office. Rachel is a corporate governance attorney. She has been my personal lawyer for 9 years. She is not flashy. She does not have a large firm or a famous name. What she has is a particular kind of precision, the kind that comes from spending 2 decades reading the documents other lawyers skim. She has a small office on the third floor of a building near the financial district, 2 paralegals, and a reputation among the people who know her as someone you want in your corner when the paperwork is complicated. I had sent her the founding documents the evening before, through Priya, exactly as I had asked. By the time I arrived at her office the next morning, she had already read them. She looked at me over her reading glasses and said 3 words. "This is airtight." Then she walked me through exactly why. The original shareholder agreement for Volantis Technologies was drafted 15 years ago by a corporate attorney named Bernard Lyle, who was meticulous in a way that I had appreciated even then and appreciated much more now. Bernard had insisted on governance provisions that most early-stage company founders wave away as unnecessary. I had listened to him. I had pushed for them. I had been in that room when every clause was written. There were 3 provisions in particular that mattered now. The first was a workforce restructuring clause. It stated in plain terms that any reorganization affecting more than 10% of the company's total workforce required written approval from shareholders holding more than 50% of the company's equity. Not a board vote, not executive sign-off, written approval from the majority to shareholder. Volantis had 340 employees. My department had 17 people. That was 5% of the workforce on its own. But Derek's outsourcing plan did not stop there. The transition to the outside firm was also reclassifying 6 additional operational roles across 2 other departments. When you added it all up, the restructuring touched more than 34 people. That was over 10%. Nobody had asked me. Nobody had sent me a written proposal. Nobody had even mentioned it to me before Derek slid that letter across the table. The clause had been violated before I ever walked into that conference room. The second provision was a CEO ratification clause. It stated that the appointment of a chief executive officer, or the formal granting of executive authority to any incoming hire at that level, required ratification by shareholders holding a majority of the company's equity within 60 days of the appointment being made. Derek had been appointed 6 months ago. That was 180 days. No ratification meeting had ever been called. William and Helen had run the board vote, believed it was sufficient, and moved on. It was not sufficient. The shareholder agreement was explicit on this point. The board vote initiated the appointment process, but it did not complete it. Majority shareholder ratification was required to make the appointment legally final. It had never happened, which meant Derek's authority as CEO was, in technical legal terms, still provisional. He had been operating for 6 months on an incomplete appointment. The third clause was the one that made Derek's letter to me not just wrong but void. It stated that the termination of any founding shareholder's employment with the company required 2 things: unanimous approval from the full board of directors and written consent from every shareholder holding more than 15% of the company's equity. I held 51%. I was a founding shareholder, and I was the one being terminated. I had not consented. I had not been consulted. There had been no board vote on my specific termination. Derek had framed the entire thing as a department elimination, a restructuring decision, not an individual termination requiring board approval. Whether that framing was deliberate or simply careless, it did not matter. The clause did not distinguish between the two. If a founding shareholder above the 15% threshold was losing their employment, the process had to be followed. It was not. The termination letter Derek gave me was legally void. I sat in Rachel's office and listened to her walk through each of these points. I already knew them. I had known them for 15 years, in the way you know where every load-bearing wall is in a house you built yourself. I had never needed to use them. The provisions had always felt like insurance, the kind you hope you never claim. Now I was claiming. Rachel asked me how I wanted to proceed. She said we could move immediately if I wanted. We had more than enough to file. I told her no. Not yet. I told her I wanted 30 days first. She tilted her head slightly, I explained. Derek had given me a 30-day severance window. I intended to use every single day of it. Not to accept the terms, but to build something that would make the final move impossible to counter. When we filed, I did not want to give them a gap. I did not want to give them a loose thread to pull. I wanted the case to be so complete, so documented, so layered, that the only rational response was to fold. Rachel looked at me for a moment. Then she nodded. 30 days, she said. Then we go. I have always believed that preparation is the most underrated form of power. Anyone can get angry. Anyone can threaten. Anyone can fire off a letter and make noise. But noise alone does not win anything. Noise gives the other side time to build walls. What wins is silence, followed by something so precise and so complete that there is no wall left to hide behind. So I spent 30 days being very, very quiet. On the outside, I looked like a 51-year-old executive in the middle of a severance period. I cleared out my office gradually. I handed over transition documentation to the outsourced firm's onboarding team, professionally and without complaint. I responded to emails. I was polite in every interaction. If anyone at Volantis was watching me during those 30 days, looking for signs of a threat, they saw nothing. Inside, Rachel and I were building the case. The first thing we did was compile a full governance audit. That meant going through every board action, every executive decision, every restructuring memo from the moment of Derek's appointment to the day he handed me that letter, and mapping each one against the shareholder agreement. What we produced was a formal, dated, page-by-page record of procedural violations. When they occurred, what they violated, what the correct process should have been, and what documentation proved the deviation. By the end of the first week, we had 43 separate incidents documented. Some were small. Some were significant. All of them were real. The second thing I did was reach out to 4 of Volantis's largest enterprise clients. I want to be specific about why, because this was not a hostile move. It was a careful one. Several of those client contracts I had personally negotiated, contained a clause I had insisted on including years earlier. It stated that any material change to the key operational contacts responsible for the client relationship on Volantis's side required the client's prior written approval. I had put that clause in because I understood something about enterprise relationships that a lot of executives miss. Those clients were not buying software. They were buying stability, continuity, and a person they trusted to pick up the phone when something went wrong. That person, in most cases, was someone in my department. Derek's outsourcing transition changed every one of those contacts without a single client being consulted. I did not tell the clients what was coming. I did not ask them to take sides. I reached out with a simple professional message. I was checking in during a period of operational transition, wanted to make sure they were satisfied with current service levels, and wanted to know if they had received any communications about upcoming changes from the Volantis side. 2 clients responded within 24 hours. One of them, a regional healthcare network that had been with us for 8 years, told me they had received a form letter from a company they had never heard of, informing them that all service coordination would be transferring to a new team. They had not been consulted. They were not happy. They wanted to know who to call. The second client said almost the same thing, in slightly more formal language. I forwarded both responses to Rachel and told her to document them. Meanwhile, inside Volantis, the outsourced firm had already begun the transition, and the cracks were forming faster than I had expected. My department had not simply managed operations in the conventional sense. We were the institutional memory of the company. My team held the compliance calendars, the dates by which certain regulatory filings had to be made for specific clients. They held the vendor escalation contacts, the personal phone numbers and relationship history that made it possible to resolve a crisis in hours instead of days. They held the system access protocols, the internal documentation, the audit trail for every major client account going back years. None of that was in a manual. Most of it lived in people's heads and in internal files that had never been formally handed over because no one had thought to ask for them before eliminating the department. The outsourced firm arrived with a new team, new processes, and no context. By week 2, 2 compliance deadline reminders had been missed, caught at the last minute, but only barely. A vendor escalation that should have taken 2 calls took 3 days, small things. But in enterprise operations, small things are how you lose clients. I heard about each incident through a contact who was still inside. I added each one to the file. By day 29, I had 700 pages of organized documentation. Governance violations, client concerns, operational failures, and a financial analysis Rachel had requested showing the projected annual cost of the outsourced firm against what my department had cost the company. The outsourced firm was 30% more expensive. I printed the summary. I put it in a folder. I went to sleep at a reasonable hour for the first time in weeks. Tomorrow was day 30. On day 26 of my severance period, Derek held an all-hands meeting. I was not there. I no longer had a badge that would get me past the lobby turnstiles, and I had not tried to use one. But I had a contact inside, a senior operations analyst named Jonah, who had been on my team for 4 years, and who, like several others, was still working out his own notice period. Jonah attended the meeting. He sent me a summary within the hour. He was not trying to be disloyal to the company. He was just a decent person who thought I should know what was being said about the work we had all done together. Derek stood at the front of the main floor, where Volantis had an open atrium space we used for large gatherings. According to Jonah, he was relaxed, confident. The kind of confident that comes from believing the hard part is already over. He announced that the restructuring was complete. He said that Volantis had successfully modernized its operational model. He talked about agility. He talked about scalability. He said the word streamlined 4 times. Jonah counted, because Jonah had a dry sense of humor and had started keeping track somewhere around the 3rd time. Derek thanked the board. He thanked William Webb by name. He thanked Helen Cho by name. He spoke about the future with the energy of someone who had just solved a problem. He did not mention my name once. He referred to the previous operations team as legacy overhead. That phrase, legacy overhead, was the one Jonah flagged specifically. He put it in quotes in his message. He knew what it would mean to me, and he was right. Not because it hurt me, but because it told me exactly how Derek had been thinking about this from the beginning. We were not people to him. We were a line item, a cost to be reduced. I read Jonah's message sitting at my kitchen table with a cup of coffee that had gone cold. I noted the phrase. I forwarded the message to Rachel. Then I looked at the rest of what had come in that morning. The outsourced firm had sent Volantis a quiet invoice for emergency overtime charges. The invoice was not public, but a copy had been routed through a shared billing inbox that one of my former team members still had access to during the transition. The overtime had been billed because 2 major client compliance deadlines had nearly been missed simultaneously in the same week. The firm had thrown extra hours at the problem to close the gap. They had closed it, but barely and at cost. More importantly, one of those 2 clients, the healthcare network I had spoken with earlier in my 30-day window, had now escalated formally. They had sent a written letter of concern to Volantis' board, not to the new operations team, not to Derek, not to William or Helen. They had sent it to the chief operating officer. They had sent it to me, by title, because they did not know I was gone. The letter was addressed to the office of the COO, Volantis Technologies, and it expressed serious concern about service continuity, the lack of prior consultation regarding operational changes, and what they called a material shift in the relationship structure that they had not consented to. They asked for a response within 10 business days. They referenced, without naming the clause directly, the language in their service agreement about operational contact changes. A copy was forwarded to my personal email through a channel I will not identify, but which was entirely legal. I printed the letter. I added it to the folder. Then came day 28. William Webb sent a company-wide email. The email positioned him as the senior oversight presence for operational continuity in the current transition period. He used careful language. He did not say he was the COO. He said he was providing board-level operational guidance during what he called a bridge phase. But the implication was clear. He was stepping into the gap that my removal had created. He was making himself visible in a role that did not formally exist. The email was internally visible. It was time-stamped. And it directly contradicted the core argument Derek had made to the board when he proposed the restructuring, that the outsourced firm was fully capable of handling all operational functions without any internal bridge support. William had just admitted, in writing to the entire company, that there was a gap. He had documented it himself. I read the email twice. I forwarded it to Rachel with a single word. "Perfect," she replied 30 seconds later. "I know." Day 30 was a Thursday. I woke up early. I made coffee. I sat at my desk at home and I read through the full file one more time. Not because I needed to, but because I wanted to be certain that every page was exactly where it should be, that every document was dated correctly, that every connection between violation and absence was clean and clear and impossible to argue with. Then I called Rachel. She had been ready since the night before. She had the notice printed, signed, and waiting. All she needed was my confirmation. I gave it. At 10:45 that morning, Rachel's office sent the same document to 3 separate destinations simultaneously. The first was Volantis' registered corporate mailing address. The second was the personal business addresses of each sitting board member, including William Webb and Helen Cho. The third was the outside legal counsel that Volantis used for corporate matters, a mid-sized firm that had been on retainer with the company for several years. The document was 12 pages long. It was not a lawsuit. I want to be specific about that, because I think people assume that the first move in a situation like this is to file in court and make noise. That is not how it works when you know what you are doing. A lawsuit at that stage would have been premature, expensive for both sides, and slower than what I actually needed. What Rachel sent was a formal shareholder notice, a specific type of legal document recognized under the shareholder agreement, and the company's governing documents, calling for an emergency governance review. The notice identified 3 procedural violations by name, by date, and by specific clause reference: the unauthorized workforce restructuring, the defective CEO ratification, the void termination of a founding shareholder. Each violation was laid out plainly, with the relevant clause of the shareholder agreement quoted beside it and the documented evidence listed in an attached appendix. The notice formally invoked my right, as the holder of a majority equity position, to call an emergency shareholder meeting. Under the agreement, that meeting was required to take place within 14 calendar days of the notice being received. And then there was one more line. It noted formally and in precise legal language that the appointment of Derek Richardson as Chief Executive Officer was being placed under governance review pending completion of the required majority shareholder ratification process. Until that process was completed, his executive authority should be considered provisional and subject to challenge. I want you to think about what that line meant. Derek had been running Volantis for 6 months. He had restructured departments, terminated employees, signed vendor contracts, made board presentations, sent company-wide announcements. He had done all of it under an authority that had never been properly completed. And now there was a 12-page legal document, sent simultaneously to the board and the company's own lawyers, saying exactly that in writing. The notice landed on a Thursday. By Friday afternoon, Volantis' outside legal counsel had read it, and I know this because by 2 o'clock that afternoon, they had called an emergency session with the board. I know this because I was still on the board. This is the part that Derek never knew, that nobody had apparently thought to check. When I was terminated as an employee of Volantis, my employment agreement was voided. My CO title was removed. My access badge was deactivated. But my position as a founding board member was a separate designation established in the original corporate governance documents, with its own terms and its own conditions for removal. Terminating my employment did not touch it. Removing me from the board required a separate board resolution with a specific vote for which there were specific procedural requirements. No one had filed that resolution. No one had held that vote. No one had, apparently, ever looked at the board composition document close enough to notice that I was still on it. I received the meeting notification through the official board communication channel, the same channel I had always used. I drove to the Volantis building on Friday afternoon. I was dressed the way I always dressed for board sessions: a dark blazer, dark trousers, a white shirt. Nothing different from any other time I had walked through those doors. The receptionist on the main floor was someone I did not recognize. She had clearly started recently. She looked up when I came in and asked if she could help me. I told her I was there for the board session. She checked her screen. She looked uncertain. She said the session was listed as a closed executive meeting. I told her my name. I told her I was a sitting board member. She looked at her screen again, longer this time. Then she picked up the phone and made a short call. She listened. She set the phone down. She told me to go ahead. I walked through the turnstile and into the elevator and up to the 14th floor. The same floor with the same conference room, the same table, the same windows looking out over the city. I opened the door. Derek Richardson was standing at the head of the table. William Webb was to his left. Helen Cho was seated to the right. 2 lawyers I did not recognize were on the far side. Derek looked up when I walked in. I will not try to describe his exact expression in detail, because I do not want to be dramatic about it. What I will say is that the color left his face in a way that told me everything I needed to know. In that single moment, something shifted in the room. Everyone felt it. I sat down in my usual chair. I set my folder on the table in front of me, and I said calmly that I believed we had a meeting to get through. The emergency shareholder meeting was held 11 days after Rachel's notice landed. In the time between that Friday board session and the formal meeting, I was told later, William and Helen had spent a significant amount of money trying to find a way out. They hired a larger firm, one of the downtown practices with a full corporate governance team, and asked them a simple question. Is there a way around the shareholder agreement provisions? The answer came back the same way Rachel's assessment had come back to me. No, there is not. The agreement was drafted precisely. The clauses were specific. The equity thresholds were clearly stated. There were no ambiguities to exploit, no procedural gaps large enough to walk through, no interpretive arguments that would survive a challenge. The provisions meant what they said. Their own lawyers confirmed it. So they arrived at the shareholder meeting, having spent 2 weeks and a considerable amount in legal fees, to learn what I had known since day one. The meeting was held in a neutral location, a law firm's conference room, not Valantis' offices, which was standard for a formal shareholder proceeding. Present at the table were Mara Sutton, me, and Rachel Ossie as my legal representative, William Webb, Helen Cho, Derek Richardson, and Valantis' corporate legal counsel, a senior partner named Graham Ash, who had been with the company's outside firm for several years and who I noticed looked considerably less comfortable than the last time I had seen him at a routine board session. Graham's discomfort made sense, because Valantis' outside counsels had technically been the legal presence during Derek's onboarding. They had not caught the ratification failure. They had not flagged the governance charter provisions. They were now sitting in a room where those failures were about to be formally entered into the record, and they were representing the company that had made them. That was a complicated position to be in. Rachel presented first. She was calm and completely without drama. She walked through the governance violation record the way you would walk someone through a spreadsheet. Line by line, date by date, clause by clause. The unauthorized restructuring affecting more than 10% of the workforce. The CEO ratification that had never been completed in the required 60-day window. The void termination of a founding shareholder conducted without the required consent. She cited each clause. She presented each piece of documentation. She noted the dates. She did not editorialize. She did not raise her voice. She simply placed the record on the table and let it sit there. When she finished, Graham Ash acknowledged, quietly and carefully, that the procedural violations as described were accurate. I watched Derek's jaw tighten when Graham said that. William looked at the table. Helen did not change her expression at all. Then it was my turn. I told them I was not there to destroy Valantis. I meant that. The company was 15 years of my life. The people still working inside it were people I had hired, trained, and in some cases known for a decade. Whatever had been done to me by the people in that room, my anger at them was not worth burning down something I had spent that long building. I was there, I said, to protect it. Then I opened my folder. I presented the client situation first. The formal letter from the healthcare network, addressed to the COO, addressed to me, because they did not know I was gone. The responses from 2 additional enterprise clients flagging concern about the operational changeover they had not been consulted on. The clause in each of their service agreements requiring prior written approval for any change to keep operational contacts. Derek's transition had triggered those clauses without a single client being notified in advance. That was not just an operational problem. It was a potential contractual breach multiplied across 3 client accounts. Then I presented the outsourced firm's performance record since the transition, the emergency overtime invoice, the 2 compliance near misses, the vendor escalation that had taken 3 days to resolve. I presented it without commentary, simply as documented fact. Then I presented William's email, the one he had sent company-wide on day 28, positioning himself as the operational bridge in my absence. I placed a printed copy in front of every person at the table. I let them read the line where he described himself as providing board-level operational guidance during the transition. I noted that this directly contradicted the representation Derek had made to the board when proposing the restructuring, that the outsourced firm was fully self-sufficient and required no internal support. Then I presented the financial comparison. On an annualized basis, the outsourced firm cost 30% more than my department had cost Valantis. Not less, more. The efficiency argument that had been used to justify the restructuring was not supported by the numbers. And finally, I presented the client retention data. In the 6 weeks since Derek's restructuring, Valantis' enterprise client retention metric had dropped 8 points. 2 clients, together accounting for 22% of the company's recurring revenue, had sent preliminary signals of non-renewal. Those signals were early, they were not final. But they were documented, and they were real, and they were directly traceable to the operational disruption that followed my department's elimination. I closed the folder. I said that what I had presented was not a threat. It was a picture of what had happened to Volantis in 6 weeks under a set of decisions made without proper governance, without proper consultation, and without proper understanding of the company's operational dependencies. I said I was prepared to discuss a path forward, but that path had to begin with an honest acknowledgement of where things stood. Derek spoke after me. He talked about long-term transformation. He talked about short-term disruption being a natural part of meaningful change. He used the phrase change management curve and talked about how the numbers would stabilize. He was composed. He was professional. He was working hard to sound like a CEO who had a plan. William backed him. He talked about the board's confidence in the strategic direction. He talked about the outsourced firm needing more time to fully integrate. He said the client concerns were being addressed. Then Helen Cho, who had not said a word since the meeting began, looked up from the documents in front of her. She spoke slowly. She said she had read everything Rachel had presented. She said she had also read the findings from the firm she and William had retained to review the shareholder agreement. She said she was not prepared to dismiss the governance violations as procedural technicalities, because in her assessment they were not technicalities. They were structural failures that exposed Volantis to material legal and financial risk. She said she did not believe that risk was acceptable. And then she said she was prepared to support a resolution to address the governance failures, as Mara's notice had outlined. The room went quiet. William turned to look at Helen. She did not look back at him. Derek said nothing. He had run out of road. With my 51% and Helen's 15%, the shareholder block was 66%. William held 27. The remaining 7 was the employee pool, non-voting on governance resolutions of this type. The math was not close. William sat back in his chair. Derek looked at Graham Ash. Graham Ash looked at the table. I looked at no one in particular. I just waited. The resolution came within 72 hours. Derek Richardson's appointment as CEO was formally rescinded on procedural grounds. The language was careful. It cited the failure to complete the required ratification process within the 60-day window as the basis for unwinding the appointment. It did not use words like fired or removed. Corporate documents rarely do, but what it meant was plain. He was out. His contract, which my operational team had reviewed and processed during his onboarding, contained a clause that most executive agreements of that type include only as a formality. It voided severance entitlement in the event that the appointment itself was found to be procedurally defective and subsequently unwound. The clause had been there from the beginning. It had been drafted by the same careful process that produced every contract Volantis had signed under my oversight. Nobody had flagged it during Derek's onboarding review because it had seemed like standard language. It was standard language. It just happened to apply now. Derek left without the exit package he had expected. The outsourced operations firm's contract was terminated the following week. That contract, like every major vendor agreement I had ever negotiated for Volantis, contained an early termination provision. It required 60 days' notice and a standard wind-down fee, with one specific carve-out. If a majority shareholder formally requested a contract review on the basis of performance or governance concerns, the 60-day window could be triggered immediately without penalty. I requested the review. The notice went out the same day the resolution was signed. William Webb's situations resolved itself over the following month. With Derek gone and the governance violations on the formal record, his position on the board became difficult to hold. I invoked a separate shareholder rights provision, one that allowed for a formal review of any board member whose actions had materially contributed to a documented governance failure. William did not wait for that review to conclude. He negotiated his stake and stepped down quietly, the way people do when they understand that staying will cost more than leaving. He sold most of his 27% stake to Helen Cho. Helen bought it with the precision of someone who had been waiting to see which way the situation would fall before deciding how much of it she wanted. Once it fell her way, she moved quickly. I did not buy it myself. I did not need to. My 51% had always been enough. What I cared about was that the stake went to someone with clear eyes and an honest read of what Volantis actually was. Helen and I have a functional working relationship now. We are not close friends. We do not need to be. What we are is two people who understand each other's position clearly, which in a business context is worth considerably more than friendship. I reinstated my department. Not all 17 people came back. Life had moved forward for some of them in the weeks since the termination. New roles, new commitments, decisions made while the future was still uncertain. I understood that. I did not pressure anyone. But 12 of them returned, including the 3 Scenes leads who had been the backbone of what we built. We were smaller for a while, we rebuilt carefully. Within 4 months, the operational metrics were back to where they had been before the restructuring. The enterprise clients stayed, all of them. The healthcare network sent a formal letter, addressed to me this time because they knew I was back, saying they were glad the relationship had returned to its established structure. I kept that letter. It is the only document from this entire episode that I printed and did not file. I have thought a lot since then about what this whole experience was. It was not a dramatic story, not really, not in the way I think people expect when they hear the headline. There was no single explosive confrontation. There was no moment where I stood up in a room and delivered a speech. I did not humiliate anyone in public. I did not set out to destroy Derek or William. I set out to correct what had been done, using the tools that had always existed for exactly that purpose. The tools worked because I had been careful. For 15 years, I had been careful. I had read the documents. I had insisted on the right clauses. I had built systems that were designed to function correctly, and in a strange way, they functioned correctly this time too. They just corrected in my direction instead of running smoothly in the background where no one noticed them. I think about Derek sometimes, not with anger, with something closer to a tired kind of understanding. He was not an evil person. He was an ambitious person who had been given incomplete information and had never thought to ask for the rest. In a different company, with a different structure, he might have been fine. But he walked into Valanis and assumed he understood it because no one had told him he didn't. And the person who could have told him, who was sitting across from him in board sessions and briefing him on client accounts and answering his questions about vendor contracts, was this person whose 51% he had never looked up. There is a version of this story where I am bitter, where I spent those 15 years resentful of being overlooked, angry about being passed over, waiting for the moment to burn it all down. That is not the version I lived. I was not waiting for revenge. I was waiting for whoever needed correcting to make the move that would require me to correct them. Derek made that move on a Tuesday morning in October, in a conference room I had personally designed, across a table I had personally chosen. I corrected him. The most dangerous thing you can be, in a room full of people who have underestimated you, is simply prepared. I built the company. I wrote the contracts. I stayed in the rules. And when someone tried to erase me, the rules I wrote erased them first.